challenges to this morning?
No.
Anything on behalf of the people for allocution today?
This case is a struggle because I see the recommendation for rehabilitation, but the fact is, Ms. Leal has had the chance for rehabilitation throughout her whole life. I mean, we've been dealing with Ms. Leal's addictions and criminal history, I mean, pretty regularly. I mean, she's only 39 years old. She has 7 felonies, 6 misdemeanors, and a juvenile record. You know, everything from tampering to, you know, what we have here with contraband in the jail, maintaining a drug house. It just goes on and on and on. I think the recommendation is appropriate because she's earned that, but I do hope that when she, if the court gives her an MDOC sanction, when she gets out, she actually thinks to herself, maybe I need to get into these programs without the court forcing me to, because I actually need these programs. She looks better than she does. I mean, she's pretty easy to tell when she's on meth, and it's just been an ongoing problem with her. So I hope she takes this seriously, and I hope the court follows the recommendation. Thank you.
Your Honor, Ms. Leal is 39 years of age. The court is aware of her criminal history. She has 6 prior misdemeanors, 7 felonies, majority of them all drug related. I think everybody here in the courtroom would agree Ms. Leal looks a lot better. She's feeling healthier, and part of it is she's sober enough on the drugs. Ms. Leal took some initiatives to engage in treatment, reached out to Catholic Human Services. She did get a acceptance to the lines then, and what Ms. Leal is requesting the court is to not incarcerate or send her to prison, but deviate downwards. The guidelines are what they are. She's on those guidelines, but give her a chance to complete a long inpatient treatment at the lines that will last how much about a 9-month program. And if she's successful, to hold any jail time or any other incarceration demands. If the court were to sentence Ms. Leal to a prison sentence, she would ask for the court sentence and then to the lower end of the guidelines. So Ms. Leal could at least take advantage of getting out early and getting back with her sobriety and maintaining sobriety. Thank you.
Thank you, Ms. Leal. Anything you wanted to say? Yeah.
Yes, Your Honor. First, I'd like to apologize. I'm sorry I'm in front of you again. I know that I have a really lengthy criminal record, but like I didn't know until I met this peer recovery coach that I could actually use all of like my drug experience and my trauma and stuff to become a recovery coach like her. In the Lions, then they actually offer a program after the 9 months for another 10 months to train to be a recovery coach. And that's what I was hoping to do. I was hoping to maybe get like a county year and then do the 1.5 years at the Lions thing.
All right, Ms. Leal, I did read through the report, so I'm familiar with the circumstances that led to the charges in this particular case. I'm familiar with your background in history, the information in the report about that as well. So I'm fully versed in all of that information and take all of that into account along with what the lawyers had to say here and what you've had to say. I don't think anybody doubts the fact that you do need to get into a treatment program at some point. That's the only way that you're going to be able to move on from this. It's pretty clear that everything that you've done up to this point hasn't worked. Everything the court's done in terms of probation, talked to Baby Macalda, he's indicated he's tried to get you into treatment before. You either haven't gone or it hasn't worked. So I do think that's something that you need to continue to seek out if you want to stay out of jail or prison. Unfortunately, at this point where you're at, that's really not an option for me. As Mr. Murthy indicated, I would have to depart downward, and I have to have good reasons for departing downward. Here, unfortunately, just your expression of a willingness to go to a place like the Lions Den isn't enough of a reason legally for me to go below the guidelines in this case. And frankly, I don't see anything that's gone on in the past that would indicate to me that giving you that opportunity at this point would be worth the risk to the community and the risk that you would go back out and engage in helping other people get meth and treating yourself and other substances are even more dangerous. So I I don't think there's any reason why you can't seek out a program like Lines then. It's still gonna be there when you're done serving your sentence. There's no reason, just like Ms. Coates said. You have to wait for the court to order you to do that. You can do it at any time that you want. And so if you're serious about it, I hope you can follow through with that. As it is in this case, I do think that a recommendation, a sentence, particularly on your most serious charge, which calls for up to almost 5 years in prison. I think a sentence in the lower third of those guidelines, which would put you, in the mid to upper range in your other sentences, which are lower guidelines, I think is appropriate given all the circumstances here. So as to file number 5514, count 1, possession of methamphetamine, court will order that you serve a sentence of 36 months to 20 years. Because of your status being on parole at the time, you are entitled to 0 credit. And that sentence to be served consecutive to any parole violation sanction. The court will order a crime victim's assessment of $130, court costs of $325, attorney fees of $250, DNA testing fee of $60, and a $204 state cost. On that file, as to count 2, possessing contraband in the jail, court will sentence you to 24 months to 10 years. Again, credit for 0 days served. That to be served concurrent with count 1, but consecutive to any parole violation sanction. Count 3, maintaining a drug house, 24 months to 4 years. Credit for 0 days served, so to be served concurrent to counts 1 and 2, but consecutive to any parole violation sanction. You do have the ability to seek an appeal of the sentence. Provided Ms. Leal with her appellate records.
Yes, sir. Ms. Leeds acknowledged her appellate paperwork.
Mr. Thompson, did you have Mr. Jackson present?
Yes.
Okay. We'll call People versus Christopher Jackson, file number 255496.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Christopher Jackson. Your Honor, we were here on January 8th. I had placed a request on the record to have lab reports in this matter. Those still aren't in. I got a message on February 23rd that they were about to be sent to the lab. So from our perspective, that's hindered our ability to engage in plea discussion or be prepared for trial. But we're asking the court to set this matter for trial at this point, probably with the final status conference.
Ms. Coke, how much time do you need to be ready for trial in this case?
We'd ask for 60 days.
Is that enough time, Mr. Thompson?
Yes.
We'll set it for a 60-day jury trial. Ms. Coke, is 1 day enough?
Yes.
Yes.
Set up for a 1-day jury trial, about 60 days out. I think I have. So as a practical matter, it's probably going to be June for trial date, just because I have.
All right, I'm out the last week of May, so that's fine.
Okay. So the court will set it for a final status conference prior to the trial date. Ms. Coke, are you anticipating any motions in this case?
No.
No.
So Mr. Jackson, you're going to get a notice of the date and time of your trial date. And then we'll have one final hearing before that trial date. To the extent that you want to consider any plea offers, that would be the last date to enter into a plea. So it's important that you stay in touch with Mr. Thompson and that you're ready with a final decision on that.
And Your Honor, that does remind me, I'm asking the court to update Mr. Jackson's mailing address.
Okay.
3414 Chambers Street, Flint, Michigan, 48507.
That is the address I have.
Okay, all right, thank you.
Yeah, I had recently moved back.
Okay, yeah, because I haven't received any mail back, but, yeah, that is the address I
All
have.
right, thank you.
Okay.
Okay, thank you, Your Honor.
Mr. Jackson, do you have any questions about how we're going to proceed with your case?
No, sir.
Okay. Thank you. That's all for today. Mr. Tremblay, if you'd like to come forward. Go back on the record from Mr. Tremblay's case. Mr. Thompson, how did?
Mr. Tremblay intended to plead guilty to count 4, violation of state law, which is a non-technical violation. And that's based on the plea he tendered in Roscommon, which was to an attempted assault.
Okay, so Mr. Tremblay, you've had a chance to talk to Mr. Thompson.
Yeah, Your Honor.
Did you want to move forward with that plea today? Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Mr. Tremblay, you understand that you have the right to have a hearing as to whether or not you violated your probation?
Yeah.
You understand that by pleading guilty, you're going to be giving up that right?
Yes.
Also, by pleading guilty, it could subject you to the maximum possible penalty on your underlying charge, which is possession of methamphetamine, and that's up to 10 years. You understand that? Yeah. All of that in mind, what is your plea to the probation violation today?
Guilty.
Has anybody threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anybody promised you anything other than what we said here on the record today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you did violate your probation? Yes. On or about November 6th of 2025, were you on probation here in Crawford County?
Right. I'm not sure if it was here or Roscommon.
You might have been supervised in Roscommon, but your probation was here in Crawford.
Yeah, here.
And were you aware that one of the conditions of your probation was that you were to not violate any laws of the state of Michigan?
Yes.
Did you violate a law of the state of Michigan by pleading guilty to, what was it, attempted resistant obstruction?
Yes.
The court finds that the plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you did violate your probation as alleged. The court will, that count 4, the court will accept your guilty plea to that count. We're going to set this for a probation violation sentencing hearing. You'll be notified of the date and time of that hearing. You're going to meet with Mr. Falvey here today.
Yeah, why don't you provide a good address for the court? Make sure you get notice.
106 South 2nd Street.
Okay, thank you.
Mr. Tremblay, it's important that you stay in touch with Mr. Thompson prior to that hearing, okay?
Will do.
Thank you.
Thank you.
Mr. Thompson, do you have Mr. Is it Queck?
I received a message that Mr. Queck was running late. I don't see him in the courtroom yet. Ask the court to pass that matter for a couple minutes. Thank you.
Are you ready for Ms. Leland once we have her brought up? What? Underway. Okay.
I'd like to speak to her in the hallway. if I could.
Is Mr. Phillips here?
Mr. Phillips is here, we're ready.
Okay. Let's take,
After we're done with the changes, assuming that Mr. Phillips.
we'll call People versus Anthony Phillips, file number 265522. The record should reflect Mr. Phillips is present here in the courtroom today. If I could have counsel get the appearances on.
Sierra Coke on behalf of the people.
Thank you, Madam President. I think Terry on behalf of Mr. Phillips is just standing to my left.
Okay, so Mr. Germerty, I understand that we have a no contest plea.
I do, Your Honor. The reason for the no contest plea is lack of memory and degree of inebriation. Mr. Phillips does not recall the events. I did submit a police report. I think that establishes factual basis I did submit the lab results as well. It's 0.24, and I stipulate to its use as well to support both the no contest plea and the count 3 plea.
Ms. Coe, do people have any objection to the court taking a no contest plea for the reasons stated?
Yeah.
Yes, I will send it to you in a second, Sarah. I'm gonna pull it up.
And what is it again? I'm sorry.
No, we count 3 operating on intoxicated and then count 5. The code for that is 257.60282.
Yep, that's correct.
So misdemeanor OWI.
Yes, 93 to misdemeanor, and then a 2-year felony on fleeing elude in 4th degree. Counts 1, 2, and 4 will be dismissed.
All right. Mr. Phillips, have you had an adequate opportunity to speak with your attorney about this agreement?
Yes.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Mr. Phillips, are you on any kind of probation or parole?
As of right now, no.
Okay. And you understand that by pleading guilty to count 3, which is operating while intoxicated, that's a misdemeanor that carries with it a maximum possible penalty of up to 93 days of jail and or a $500 fine.
Yes.
And that pleading guilty to fleeing and eluding 4th degree is a felony that carries with it a maximum penalty of up to 2 years. With those penalties in mind, what is your plea to those 2 charges today?
No contest.
All right. Are you pleading no contest because you don't have a memory of this incident based on your intoxication?
Yes.
I'll go through your rights with you. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes.
You understand that you're going to be giving up and waiving all of those rights by pleading no contest.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. You only do that by leave, and that means you would have to ask for the Court of Appeals to hear your case. If they said no, that would be the end of any appeal.
Yes.
Does anyone threaten you with anything to get you to plead no contest?
No.
Has anybody promised you anything other than what we said here in court today? That your own free choice to enter this plea?
Yes.
Folks, have you reviewed the police report, Crawford County Sheriff's Department report number 2512000, and that's 976?
Yes,
And the information contained in that report would provide a factual basis for finding that's the count 3 and added count 5.
yes,
Done that?
Yes, and I agree.
The court is going to mark and admit that exhibit as Court Exhibit 1 and use that as the factual basis. Ms. Pope, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
no, Your Honor.
Mr. Gerber, do you?
No.
Ms. Coke, are the people satisfied that the court has complied with statute, the court will take this plea?
Yes, Your Honor.
I would agree to.
Thank you. Mr. Phillips, the court finds that your plea is knowing and voluntary. I'm satisfied based on my review of Court Exhibit 1 that there is a sufficient factual basis to support a finding that you are guilty of each of these charges. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Germer prior to that hearing. You're prepared to go forward. Before you leave today, you're going to meet with Mr. McFalda to set up a pre-sentence interview.
Okay.
That's all right. Thank you.
Just the only thing is, I did provide Mr. McFarland a copy of my client's substance use assessment. I just asked that that be attached to the pre-sentence report. I think it's required by statute for the OWI conviction, so
Yes.
So
Okay.
we'll just attach to the PSI. Thank you.
Yes, thank you. Ready, Ms. Leland?
Yes.
Ms. Leland, if you come up to the podium here, please. Go on the record in People versus Kimberly Leland. This is file number 245281. The record should reflect Ms. Leland's present here in the courtroom today. Thank you, counsel, please.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Kimberly Leland.
All right, this is the date and time set for sentencing on Ms. Leland's probation violation. Ms. Leland, did you have a chance to go through the pre-sentence report with Mr. Thompson?
Yes.
Mr. Thompson, are there any additional solutions or corrections?
Your Honor, not additions, deletions, or corrections. She did have some comments about some of the reasons behind some of the things.
Ms. Coe, any additions, deletions, or corrections?
No, Your Honor.
Anything on behalf of the people for allocation today?
Your Honor, it's not that often that we have people fail this swiftly and this terribly on when they're given a chance for a 7411. And she doesn't have any criminal history. Her husband is up for sentencing today. The court's aware of the circumstances of her charge. She got a very, very good break, a very good plea offer. The court was very lenient on her sentencing. We gave her every chance we could based on her minimal criminal history and her husband's criminal history and the amount of methamphetamine they had in the vehicle. We talked about whether or not there was a likelihood she knew all that methamphetamine was in the vehicle, and she only got sentenced on the methamphetamine on her person. I think a high end of her guidelines is appropriate. I think the revocation of her 7411 is appropriate. Frankly, had she been charged originally, she'd have been looking at a significant prison sentence. She quite clearly did not take this seriously at all. Thank you.
Mr. Thompson.
Your Honor, I guess I would take a different approach. I think Ms. Leland was charged and pled appropriately because I don't think the higher volume that she had anything to do with that. Quite frankly, I don't think anything about her relapsing changes that. She has a problem. She has a problem with controlled substances. I don't think that makes her a dealer. I think that makes her an addict who's struggling. And I think that's what's written all over this is a struggle. One of the things she did want to say is that she believed she had been to 2 to 4 treatments, that she had missed several because of doctor's appointments and some other reasons. She also relapsed, Your Honor. Her father died. She relapsed. She failed several drug tests. She has a problem and she's not on top of it yet, and she is still relapsing. So she understands that she did not live up to the terms of her probation. She understands that her addiction is even stronger than she thought it was, that the attitude and the approach and the strategies she was using to try to stay on top of it weren't enough. When her father died, she, was weak and she used. So she certainly apologizes for that, Your Honor. She understands that she is subject to a penalty today. What she told me is she kind of gave up when her dad died, and I think she is going to use this time that the court gives her to reflect on, going back at it, taking a better attitude, taking a better approach, and hopefully getting better results next time. So we understand the 7411 is likely to be revoked. We're just asking the court to take all that into consideration of fashioning a sentence. I would suggest 3 to 6 months would be an appropriate sentence. Thank you.
Thank you, Ms. Leland. Anything you wanted to say today? Sorry,
No.
Oh, okay. All right, Ms. Leland, I did read through the pre-sentence report, so I'm familiar with kind of what happened during your term of probation. And of course, I'm familiar with the underlying circumstances of your case. I've got your husband for sentencing here today. And I was familiar with your case, the original pre-sentence report. And I think the hope was, well, first of all, sorry to hear your father passed. That's a difficult thing for anybody to deal with at this stage of life. And particularly for somebody who has substance abuse issues, it's easy to fall back to that pattern and have something like that happen in hope was during the original sentencing was that we were going to place you on probation, didn't give you any additional jail time at that point. You were released with time served, and the hope was that through probation you were going to get some help and deal with this and successfully complete probation. And that clearly did not happen. In spite of what was going on in your personal life, seeing things like intensive outpatient treatment that you were referred to, peer support, individual sessions that you would have been available or had the chance to attend. Those are all things that could have helped you with father's death and with your underlying problems that helped you prevent a relapse. And I know you're contesting how many you went to or didn't go to. I tend to believe the writer of the report, they have no reason to lie about what you didn't go to or did go to. And frankly, they're a much more credible source of information than you are to me. So I believe them. And, you didn't go, you were referred to that outpatient substance abuse treatment on January 5th. And 6, 7, 11 sessions that you failed to attend. You didn't appear for drug testing on 4 different occasions, and then you did appear for testing on February 4th and tested positive. And you didn't make any efforts to pay any of the fines and costs. So really, what I see on paper is just no effort at all to comply with probation. No effort at all to use those resources to help you deal with your underlying problem or with the death of your father and how that would play into it. And you had those available to you. So to me, at this point, the whole purpose of probation and avoiding jail is to give you a chance to do those things. You've indicated through your conduct that you don't want to do that. So at this point, the option I have is to sentence you to jail. I think that's appropriate given the circumstances. Your original guidelines were 0 to 11 months. I think a sentence at the top end of the guidelines based on your total lack of compliance while on probation is warranted, both for the purposes of punishment as well as deterrence, so that other folks who are on probation see that if they're not going to try to comply, then jail is the outcome. So the court is going to sentence you to 11 months in the Crawford County Jail. You have credit for 68 days served. The court is going to order that you be unsuccessfully discharged from your probation and the 7411 status be revoked. The court will preserve any outstanding fines or costs. You do have the ability to seek an appeal of the sentence, and Mr. Thompson, if you can provide those appellate rights.
So, Ms. Lewin, I'm going to grab a pen. You're going to initial these just to indicate that you received them. You're going to walk away with 2 copies of this. You can decide if you want to file an appeal. If you do wish to file an appeal, use these forms to both file the appeal and obtain an attorney. Your first deadline is in 14 days. You're going to want to make a decision by then. Today's the 5th, correct, John?
Yes.
Thank you. All right. Ms. Leland has indicated as initial the top copy. She's going to leave with the bottom 2. Thank you.
We're set for a status conference in this matter today. Mr. Kermer, can you tell me where we're at with this?
Yes, thank you, Judge. We're asking, we set this matter for trial. I would ask we set it down, plea cutoff and trial in about 120 days or so. Defense is going to request some experts in this, and I'm still get some motions and notices she has to file. I think that's a reasonable time frame request to set this matter for trial at this point.
Okay. Ms. Koch, do you agree with this time frame?
Yes.
How many days of trial do you think we'll need?
Your Honor, we're going to have an expert. We're going to be doing a 768 and 404B on all 3 of his prior criminal sexual conduct convictions. I say that just so the court's aware. We're probably, if the court grants those, looking at 2 or 3 days. I believe defense is also seeking an expert. And it's sometimes hard to pick a jury on these type of files. So I think we can do it in 2, but we may want to set it for 3 just in case.
I think we 3 days, Judge. Defense has an expert, at least one at this point, and some of the witnesses will be duplicated from the people that took the call. But it's going to be very fact specific, so it's going to take about 2 days. I think, Judge.
Okay, I'm just curious, what kind of experts are you calling?
Yeah, we're gonna be calling the person that did the developmentally disabled, because this is a mentally incapable allegation.
Yeah, I
So
mean, I don't know anything about the underlying facts here, so.
the allegations are that Mr. Farron had sexual intercourse numerous times with a woman who was mentally incapable to make that decision. There's a developmentally disabled expert that did the evaluation in 2024. There's a companion DD case over in the other courtroom. So we're going to be having that expert to testify about her mental capabilities.
Okay, and then what kind of experts?
So we would intend to call a licensed psychologist. The incapacitated individual at the time was married to Mr. Farron. There was a legal marriage that occurred. So we would have a licensed psychologist do the evaluations regarding the IQ, regarding the capacitation, regarding her mental capacity to consent.
Okay, so the defense is not that there wasn't
Consent, correct.
sexual intercourse, that
No.
it's not gonna be on the element of the capacity.
Correct.
Okay.
And her ability to consent and whether she was in that position.
Sure, okay,
And then, of course, the court orders that were entered in the DD file and the requirements that order had would play into whether those would then follow.
okay. All right. So Ms. Koch, I mean, do you have a time? Well, first of all, I guess my question is, you got some other acts evidence that you want to get in, so you're gonna file notices for that.
Yes, we'll be filing those within 30 days, probably sooner.
Okay, so Mr. Germerthy, I mean, you're probably aware, but once those are filed, it's my view that for the defense to challenge those.
Correct. I'll file an objection and set for a hearing, correct.
Okay.
And I don't have, my understanding is there's about 3 or 4 different prior acts. I just don't have all that information. So that'll just take some time to get those reports and what Ms. Koch alleges, and then for me to respond to those.
Okay, so, but we'll need to have those hearings prior to that final status conference.
Yes, sir.
And then, are you going to be challenging any of Ms. Koch's witnesses,
Lay witnesses?
lay or expert? I just want to know if that's going to be an issue that we need to address prior.
I don't think I'm going to challenge the lay witnesses. I think from the information that I received in felony information, we would have the same witnesses. The expert, I believe that Ms. Koch is going to call is the same expert who did the evaluation in the DD file. If that's the expert, no challenges there either.
Oh, and Ms. Koch, are you going to be challenging their witness? Their expert witness?
They haven't had an evaluation done of Miss Bean that I'm aware of. I don't know who their expert is, what their expert's going to say, or how they're going to manage to get another DD evaluation done on a victim whose guardian certainly isn't going to consent to another evaluation. So I imagine there's going to be some issues in that regard. I don't know if they are yet because I didn't know until today that they were going to try to get another evaluation done.
So there's 2 issues with that. And again, just full disclosure, my expert most likely would be Dr. Wayne Simmons out of Traverse City. I think he's testified in court before. Court's familiar with Dr. Wayne Simmons and his and I'll get on a resume and so on.
I'm familiar with Dr. Simmons.
And that's who we're in discussions with right now.
Gotcha.
I don't have anything at this point. I don't have the funding approved by MIDC at this point. So that's in the works. I just spoke with Mr. Thompson this morning, again, asking about the funding. The verbal approval I got this morning was, yeah, no problem, but I have to have that in writing to get that funding to Dr. Simmons. So that's just the procedural behind the scene issues. It's not a delay on our part, it's just the paperwork that needs to follow through to get that.
Okay.
My intent is to have Dr. Simmons review the reports that the other expert prepared and conducted and work to that. If we need another evaluation, I'll certainly reach out to Mr. Thompson, who represents complaining witness in the matter. If we have consent to do another eval, we will. I'll come back to court with a motion. That's the plan, at least at this point.
Okay, all right. All right, thank you. I appreciate that. It sounds like this is going to be not our usual case, so I want to make sure I understand kind of what the issues are so that we can schedule and stay on top of it so it doesn't delay the trial. All right, so we'll have the trial set for 120 days, 3 days jury trial. I will ask the council, file any motions related to any of the issues we've discussed here today. And get those set for hearing no later than the date of the final status conference, which will also be complete cutoff. Any other dates, Ms. Coe, that you'd like to request the court to schedule?
No.
Mr.
Not at this time, Judge, thank you.
Mr. Farren, do you have any questions about how we're going to proceed with your case?
No, sir.
All right, thank you. That's all for this hearing today.
Thank you, Judge. See you Wednesday. That concludes my docket for the morning.
Okay.
Thank you.
Mr. Leland, present here in the courtroom. So they can have set for sentencing. Mr. Leland, have you had an opportunity to go through the pre-sentence report and talk to Mr. Vernon about that?
Yes, sir.
Mr. Vernon, are there any additions, deletions, or corrections to that report?
No, no.
Are there any challenges to the scoring of the guidelines?
So we had a quite, I don't think it rises to the level of challenge. We were just looking at the scoring of OV-19 on whether there was a basis for the 10 points that were scored. I did some research. There's unpublished case law on both ends, stating that if simply providing false information to the police officer during the investigation, there were some cases that identified that it was appropriate to score or allowable to score, and some that said it wasn't. I didn't feel like there was enough information there to make that argument one way or the other, and it doesn't look like it changes the scoring, or that it doesn't change the guidelines. So
Okay.
just wanted to bring it to the court's attention.
Okay. Thank you. Ms. Cope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the score?
No, Your Honor.
Anything on behalf of the people for allocation?
You're right. I mean, the court's really familiar with this circumstance. I think we've already dealt with the other case with his co-defendant and his wife. The amount of meth in Mr. Leland's criminal history, I believe, supports the scoring the MDOC did, and the recommendation is appropriate. I'd ask the court to follow it. Thank you.
So, Your Honor, we would ask the court to consider something on the low end of the guidelines. It seems that the recommendation for 12 years is a very long penalty. And Mr. Leland has a strong support system. He does have mental health problems that I don't think contributed to this, but certainly will become a problem the longer he is lodged. So I don't know that I think if the court should consider the quality of life that he would be looking at if he spent 12 years with an undiagnosed and untreated dementia condition. So we would ask the court to at least consider those things. So yeah, we would ask the court to consider something on the low end of the guidelines.
Thank you. Mr. Leland, anything you wanted to say today?
Yeah, I'm gonna attempt to read this. I apologize if it comes out.
Okay.
My decision that day altered and possibly ruined not only myself, but the lives of the people I hold closest to my heart. My 3 children, my 2 grandsons, and my wife. I hope this makes clear the choices we make in life not only affect ourselves, but our loved ones. I stand here and take full responsibility for my actions that day. I hope all that I have hurt or disappointed can and will learn to hopefully forgive me for what I have done. I'm truly sorry for my actions, but take complete responsibility.
Thank you. Mr. Leland, I did read through the report, so I'm familiar with the circumstances that bring you here today. I was already kind of familiar with it. Your wife's case was in front of me as well. So I knew kind of about the background facts from her pre-sentence report. And I certainly got more information about that from yours, as well as specific information about you and your background, your history, circumstances generally. I take all of that information into consideration to determine what's an appropriate sentence. Of course, I listened to what the attorneys have had to say. I listened to what you've had to say here today. And looking at all the information as a whole, this was an enormous amount of methamphetamine. I think this may be the most in 13 years that I've seen an individual be found with. Usually we consider large amounts to be 50 to 100 gram range. methamphetamine sale and delivery business. And so just the weight alone is going to result in a harsh penalty for you. Also, your prior record, of course, comes into play. The guidelines in this case are 87 months to 181 months. Before I even looked at the recommendation, my view was a sentence in the middle of the guidelines was appropriate because I think the amount of methamphetamine that you were carrying justifies a lengthy sentence to make sure that you're not able to deliver that substance to other people. It causes an incredible amount of harm to our community, and people are bringing it in, making it possible for others to purchase and use methamphetamine, especially to that scale. The court has a significant interest in deterring preventing that kind of conduct, and your prior record certainly. I also think there are some mitigating factors like your health conditions, which prevent the court or convince the court that a sentence at the high end isn't appropriate either. And then I saw the recommendation, which is for 144 months, which in my view is pretty close to the middle of the guidelines. I think it's appropriate. I think it accounts for your conduct. I think it provides the community with some level of assurance that you're not going to be back anytime soon delivering this kind of amounts of methamphetamine to our community or any other communities. So the court is going to follow that recommendation. It says 144 months to 30 years in the Michigan Department of Corrections. You do have credit for 145 days served. Court will order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, and a $68 state cost. You do have the ability to seek an appeal of the sentence. Mr. Vernon, you provide Mr. Newman with appellate rights. And
We went over those before the meeting. You signed the top copy. Or initial the top copy. I give that to the clerk. 2 copies to him, 1 copy to the prosecutor.
you are in the custody of the state at this time.
I don't know.
If they're ready, if not, they have to.
5-minute answers. I can see a way to do
They're
that.
What the?
They're on their way in.
Oh. Is Deacon still in jail?
He is,
He is.
yes.
Oh. Oh, he's got.
Yes, he is, and he will be until the 19th, so.
Okay.
On a violation.
Okay, Mr. Robinson, are you ready? Mr. Wake?
Ready, Your Honor. Good morning. Yeah, come on.
We'll go on the record in People versus Mateo Wakely, file number 255479. We're here in the courtroom today.
Sierra Coke on behalf of the people.
Your Honor, good morning. Nicholas Robinson on behalf of Mr. Wakely, his presence to my left.
This is the date and time set for sentencing in this matter. Mr. Wakely, have you had an adequate opportunity to go through the pre-sentence report?
Yes, I did, Your Honor.
Mr. Robinson about it.
Yes, I did, Your Honor.
Mr. Robinson, are there any additions, deletions, or corrections?
No, Your Honor.
Are there any challenges to this?
We do not have any.
Oh, do the people have any additions, deletions, or corrections?
No,
Any challenges to this warrant?
no.
Anything on behalf of the people for eligibility?
And I think the recommendation for 18 months is appropriate. I mean, the court's aware of the circumstances that led to the search warrant, that led to the possession. Mr. Wakely's been at this for a long time. He's 61 years old. He has 3 felonies. He's been involved in some pretty egregious prior felonies. This history of dealing drugs and using drugs and going on this cycle is not new to Mr. Wakely. His guidelines are 5 to 23. I think mid to higher end of the guidelines is appropriate given the circumstances. Thank you.
Mr. Robinson.
Your Honor, thank you very much. Your Honor, concerning Mr. Wakely, and I know this might be a little bit of a stretch for this court, but I'm going to ask this court to consider a probationary term for Mr. Wakely. This is a situation that Mr. Wakely does come before this court. He does have a fairly high record. What we have here, Your Honor, and I think this is something Mr. Wakely is going to tell you himself, we have a 61-year-old man that's coming before this court with substance abuse issues. That's what this is. And we have a pattern of Mr. Wakely that whatever he has been doing with all of this, Your Honor, is simply not working for him. This is a situation where he's pled guilty to this. He has owned this. It looks like when he talked with probation, he did not make any attempts to sugarcoat this or anything like that. I should say that there is one part in here that concerns me about him telling them that he was going to rehab, but it didn't. Turned out that he wasn't. My understanding is that he did try to seek help with Grace Center, I think that it was. They didn't take his insurance and it simply didn't work out for him. But this is a situation, as I said, to where as far as the substance abuse use, methamphetamine, I think everybody in this room knows that there's no white picket fences at the end of this road. And Mr. Wakely is here and he will tell you that frankly, he's too old to be messing around with this stuff and wants the help, wants the chance. This is also a case, the set of facts, he had a gram of meth in his house. He was using it with somebody else in there. This is not good behavior, and he'll tell you that himself. But again, this is somebody that comes before this court willing and wanting the help to get himself right, Your Honor. He's fully employed. He runs his own carpet business, Your Honor. By all indications, he does an excellent job with this. And it's also my understanding this is a family business that he's continued for a period of years. So owns his own house, seems to be, to me, a productive member as far as being able to maintain employment, do good work for everybody, Your Honor. And with all of that being said, again, we're going to ask that this court to consider a probationary term for Mr. Wakely and allow him, not allow him, but almost help him get the help that he needs. Thank you.
Thank you, Mr. Wakely. Anything you wanted to say?
Yes, Your Honor. I do own up to the fact that I was doing the meth, and like Mr. Robinson said, I just want the help that I actually need, you know, because obviously I'm 61 years old and sick and tired of this. I felt like I put 10 years of my life from stress and worry. And I just feel like if I could just get some help and continue on getting help, that's my goal, is to stay clean. I mean, I've battled alcohol. I beat that. I've been sober and alcohol for over 10 years. And I just want to beat this too. I just want to continue getting the help that I need, if possible, if the court will allow me, Your Honor.
All right. I did read through the pre-sentence report, so I'm familiar with all the information contained within that report, both regarding the offense that brings you before the court here today, as well as just generally your background and your circumstances. So I take all of that information into consideration along with what the prosecutor and your attorney's done a good job of articulating the mitigating circumstances and positives about your circumstances. So I take all of those things into consideration when trying to determine what is an appropriate sentence. There's a couple things that stand out to me. You know, I read your description in here where it indicates, consistent with what you said here today, that you have an addiction problem and that you've been trying to get help and would like to get help for that. But I contrast that with what was reported from the Grace Center, and Jody Robson at the Grace Center said that you came in on October 14th. You did your intake form, and then you didn't come back, and maybe insurance was part of the reason for that. But more concerning is the indication that the defendant reported past drug abuse, but denied any current addiction issues. So I'm not sure where the disconnect comes from when you're going to the Grace Center to get help and then tell them that you don't think you have an addiction problem, but then here you are today telling them that you have an addiction problem. So it's hard for me to know what's really going on with you, and hard for me to determine therefore whether or not you really want to seek treatment or whether, you're just looking for a lighter sentence or an alternate sentence from the court. The other thing that concerns me is the indication that there were multiple controlled buys conducted at your residence. Which indicates to me that this may be more than just a use problem yourself and that you're selling, even if that's to support your own habit. That would indicate that you're putting more of this substance out into the community and making it possible for other people to abuse it, to be harmed by it. And so those factors all convince me that a sentence in the middle of the guidelines is appropriate. I think it takes into account all those things I've just stated, but also recognizes the positive factors outlined by your counsel. Your guidelines are 5 to 23 months. The recommendation is for 18. I think that's an appropriate recommendation. It's near the middle. And again, I think it accounts for all the factors here that I've mentioned. So it is the sentence of the court that you will serve 18 months to 10 years in the Michigan Department of Corrections. You have credit for 2 days served. The court will impose a crime victim's assessment of $130. Court costs of $325. A testing fee, $60, and a $68 state cost. You do have the ability to seek an appeal of the sentence. Mr. Robinson, next to you on the table there is Mr. Wakeman's appellate rights. If you can have him acknowledge receipt of those.
Does he just take this copy? Does he
He'll
need to sign
get
it?
it.
Does he need to
I
sign
get
it
the top
return?
copy, he gets,
Very
two
good.
back to him and one to the prosecutor, please.
Very good. So- Some initials right here, Dale. I can approach your staff with a signed copy, Your Honor.
Yes, please.
So for the record, Wakely has initialed his advice, or excuse me, his notice of appellate rights. I'm handing that to court staff. Mr. Wakely has a copy for himself.
Thank you, Mr. Wakely. You are remanded to the custody of the state at this time.
Yes, Your Honor.
Is there anything you want me to take out? Can you give it to him?
No. Okay, yep.
Our next hearing set for 11:45 will be in recess until that time.